Everybody wants to try to avoid probate. It's honestly a buzzword now with all of these online marketers is avoiding probate, using tools to avoid probate, offshore asset protection trusts, moving money, hiding money, dodging taxes. The truth about avoiding probate is using legal vehicles, whether they be a trust, a deed, or some other type of legal mechanism to take assets outside of probate. So there are what's called probate and non probate assets, and every state is different. I can only talk to you about Pennsylvania, Florida, and New York. And the biggest difference between both Pennsylvania and Florida in particular is inheritance tax. But we'll talk about inheritance tax in Pennsylvania in a different video. Today, what I want to talk about is the truth about wills, the truth about trusts, the truth about deeds, and how they interplay or interlock with avoiding probate. Having a will or a last will and testament is much better for your family than not having a will. One, it gives you peace of mind so that you know your family is going to receive the assets that you intended. Two, it's much cheaper for your family as well. If someone calls our firm and they don't have a will, I'm immediately thinking in my head of all the additional work that I'm going to need to do now, all the additional filings to do what's called an intestate estate. Intestate is a fancy legal word for when somebody passes away without a will. There's both testate probate, someone passes away with a will, and intestate probate, where somebody passes away without a will. So if someone has a will, a last will and testament, they do not avoid probate. Just having a will doesn't avoid probate. But what having a will does, it gives you that peace of mind, and it gives us, your family, your friends, and your attorneys, your accountants, your loved ones, the ability to find out who's going to get what. Remember, a last will and testament deals with your stuff. What happens to your stuff after you pass away? But now, importantly, and this is where we'll weave in the interplay with avoiding probate. A will has nothing to do with beneficiary designations on your accounts. For example, if I have a last will and testament and it says I'm going to give everything to my friend Johnny, and even specifically lists in the will whether or not it's a good idea. I give my Merrill Lynch account to Johnny. I give my Wells Fargo account to Johnny. I give my Bank of America account to Johnny. And then if you go to those institutions, and all of those institutions have beneficiary designations, also known as POD, payable on death, or TOD, transfer on death accounts, then what I put in my will is not valid. It's not going to operate because the designation with the financial institution, the beneficiary designation, the TOD or POD, is higher than the last will and testament. And so if you have TOD and POD accounts, and I list everything TOD and POD to Barbara Ann rather than to Johnny, even though I gave it to Johnny in my will, Barbara Ann is going to get it because I had her listed as my beneficiary on those accounts. And importantly, having beneficiary designations means that those assets avoid probate because they are automatically going to pass by operation of law, a wave of the wand by operation of law from me to Barbara Ann when I pass away. So they're not a probate asset. So that's why having a will is important because everybody knows where my stuff is going to go. But in avoiding probate is ensuring that you've taken that additional step and listed with these financial institutions beneficiary designations for what happens when you pass away. Now, that moves us into, well, okay, if beneficiary designations helps you avoid probate, what about all my other stuff? Well, you're going to have to put all of your other stuff in a trust. Right now, as we sit here in 2025, both in Pennsylvania and in Florida, the only way for probate assets to become non-probate assets is to take those assets and retitle them out of your name. because only individuals, people, can have an estate. So when a business terminates or extinguishes, there's no business estate. You don't take it to probate. Probate only has to do with what happens to a person when they pass away. What do we do with their stuff? How do we pay their debts? How do we deal with the creditors? And who is getting what in their estate? So if you have a trust is a way to move title. For example, let's say I own a piece of property. I own that piece of property in my name 100%. So George Klaus owns house. I own a house in my name. It's titled in my name. I own the property. So when I pass away, the title to my property needs to go through probate because I am a person. And people have estates when they pass away because the law wants to protect those who passed away because they can't speak for themselves. And so if I take my property and I transfer it into a trust, which is very important, we'll cover later how to do that transfer. But for our purposes today, you transfer the property from my name to the trust name. Now I don't own it actually anymore. I no longer have any ownership interest. My trust owns it. And so when I pass away, what happens to my property is controlled by the trust, not by my last will and testament, because I retitled the property in the trust. So now my property avoids probate. Then we have deeds. A deed is the legal instrument. It's a piece of paper recorded with the clerk of the courts or the recorder of deeds or the prothonotary, the clerk, the court, whatever you want to call it. It is a piece of paper that deals with the ownership of real property. Now, some states, like Florida, have what's called a ladybird deed, which is a way for property to transfer by operation of law from one person to the next. So just like a POD or TOD designation with a bank, where we take those usually probate assets, bank accounts are usually subject to probate, and we decide that we are going to automatically transfer them when someone passes away by operation of law. And the same thing can be true with a ladybird deed in Florida. And now a ladybird deed is created, it's judge-made law. It's case law. There's a case that went all the way up to the Florida Supreme Court, and the Florida Supreme Court held that this attorney or whoever it was that drafted this ladybird deed, which essentially is an enhanced life estate deed in the state of Florida, will transfer interest in real property from one person to another by operation of law, which means automatically. So if there's an automatic transfer, which means essentially all you have to do is give a death certificate and show who you are, prove who you're the named person, usually through a driver's license, those assets will automatically transfer. And so making an estate plan and building an estate plan and planning, really the key word is planning, because if you do not think about how your estate is going to transfer when you pass away, the law is going to govern. Every state has a statute that governs intestate succession, which means that the law is now going to control what happens to your stuff when you pass away. And so when it comes to avoiding probate, just to briefly recap, a last will and testament by itself doesn't avoid probate, but having a last will and testament is much better for you and your family than not having a last will and testament. A trust is a way to avoid probate, but you need to ensure that the trust is drafted properly and it's funded. You've transferred title, so those assets no longer become probatable. Because remember, there's both probate and non-probate assets. If an asset is subject to probate, it's going to go through probate, which means an attorney is going to take a fee on it. It's subject to the claims of creditors, and now your family is getting a smaller chunk of the pie later. So we want assets, if you want to try to avoid probate, to become non-probatable assets. One way, the easiest way to do that is to make those beneficiary designations on those accounts. And then we briefly talked about deeds. Having a deed is wonderful because you own property. That deed designates the ownership to the property. But in certain states, such as Florida, having a ladybird deed is one way for the property to transfer from you to another by operation of law. Now remember, there's pros and cons to everything. And so we'll get into the details of all of these different estate planning vehicles in later videos. But at least for today, from a high level, I want you to think if you're trying to avoid probate, you need to have a trust, you need to have a ladybird deed, and really what you need is all of your assets to not be subject to probate. They need to become non probatable assets. Thank you so much for watching.